Good morning, everyone. My name is Joe Weiler. I'm a professor emeritus at the Peter A. Allard School of Law at UBC. I'm co-director of the Anti-Corruption Law Program with my friend and colleague, John Ritchie. So welcome to the fourth monthly webinar in 2021 of the program. The Anti-Corruption Law Program is a joint working partnership between the Center for Business Law at the Allard School of Law, Transparency International Canada, my privilege to be vice chair of that organization, and the International Center for Criminal Law Reform and Criminal Justice, ICLR. So this is the 24th seminar or conference put on by the Anti-Corruption Law Program in the last 5 years. These three organizations that I mentioned, 5 years ago, got together in a form of collective action to create greater capacity in Canada to combat corruption through ongoing continuing professional education. So what we do is we bring together experts in this field to teach each other. That's what this is all about the best ways to fight corruption in our society. I just like to thank Dr. Carol Liao, the director of the Center for Business Law at UBC at the Allard School, and Sonia Trottier and Marcella Chan, who are providing the technical backup to make this happen today, for their very able support of the program. It's my pleasure to introduce my friend and colleague, Joe Ringwald. Joe is the president of the Geocamp International Consulting. He's former president of Scozinc Mining Corporation. Joe's got 35 years of experience in the mining and the construction field. He's been a longstanding leader in the anti-corruption field in Canada and globally. He served on the Canadian Mirror Committee for the ISO anti-bribery, which produced ISO 37001 compliance standards. He served on the Canadian Securities Mining and Advisory Technical Monitoring Committee, a former member of the board of directors of Transparency International Canada, respected author and commentator in this field, and also, I'm glad to say he's a member of the working group of the Anti-Corruption Law Program. And Joe's been a major supporter right from the get-go for our program as a panelist, as a moderator, and just his assisting and organizing our sessions, and really adds huge credibility to the efforts of the Anti-Corruption Law Program. So it's my pleasure now to turn it over to Joe Ringwald, and he's going to be our moderator today. Over to you, Joe.
Thanks, Joe. And hopefully the audience doesn't get too confused with Joe. Particularly with, the name on Joe Weiler is now corrected. Thank you. I don't know if you can see through Zoom, but I'm blushing. Today, I hope people will get some value from the program that we have. We have an incredible panel, and I think the topic is incredibly relevant to the current world situation. And as we see in dozens of countries right now are dealing and perhaps struggling with the issue of ESG, even identifying what it is. So today we're going to delve into that. But first, can I see the next slide, please? Here is just a simplified description of ESG, using the three words: the environment, how we engage with the natural world. Social, how we engage with each other. And governance, how we engage with ourselves. That's where integrity and transparency begins. So to look at these three areas, consider through the presentations and all the way into the Q&A at the end of the session, how are these areas vulnerable to corruption? Next slide, please. One aspect, and we've seen over the years, the confusion with ESG is where does it lie with other things? So ESG ties to project governance, and project governance relates to social license to operate as corporate governance relates to CSR. And social license to operate must complement your CSR policy within the corporation. They cannot be unique and distinct. They must work together. But the key here is that project governance, which is your core of ESG, is more granular and at the front lines of a corporation's business. Where what we see globally is there has been this confusion with corporate governance. They're related, but they're not the same. Just think of them as cousins. And our next slide, please. So we have an impressive panel. Judge for yourself as you listen to them and get to know them. First, our keynote speaker is Sherry Meyerhofer, who is appointed Canada's first ombudsperson for responsible enterprise in spring of 2019. She established the office as ombudsperson at the beginning of May 2019. Ms. Meyerhofer is a Canadian lawyer with 17 years experience in the upstream oil and gas industry and 13 years experience in international governance, rule of law, and human rights. She has worked in Bhutan, Bolivia, Cuba, China, India, Jamaica, Myanmar, Nepal, Russia, and the United States. She has a Juris Doctor from the University of Saskatchewan and is a graduate of Harvard Kennedy School with a master's in public administration and certificate in management, leadership, and decision sciences. Well qualified to be Canada's ombudsperson. Welcome, Sherry. Our panelists, we're very pleased to welcome Dr. Daniela Camizo dos Santos, who is an expert in extractives and ESG with extensive national and international experience in sub-Saharan Africa, South America, and Asia. She's a principal consultant at Invenient Solutions Consulting. She's practiced law in the oil, gas, and mining industries for more than 20 years, where she worked at McCarthy Tetro, Shell, Hatch, and Vale. She's presently a board member of Transparency International Canada, has been appointed by the ICC Canada as a member of the task force on addressing issues of corruption in international arbitration, and the UN Development Program has recognized her as an extractives expert. In British Columbia, back here on the West Coast, she's a member of the Environment Appeal Board, Forest Appeals Commission, and the Oil and Gas Appeal Tribunal. She gets around. She's lectured at a number of universities, including the University of Toronto, Western University, and Osgoode Professional Development. She has a BA from American University of Rome, an LLB from Osgoode Hall, a master's in natural resources, energy, and environment from the University of Calgary, and a doctorate from the Faculty of Law in University of Toronto. She's zooming into us from Brazil today. Our next panelist, Sharon Singh, is a partner at Bennett Jones. She provides practical, strategic, and innovative legal solutions to clients for their priority and complex jobs. And I think those of us who are familiar with the extractive industries know that just about every project is complex. She specializes in providing advice on regulatory, governance, environmental, and Aboriginal law to infrastructure, mining, energy, and construction technology, agribusiness, and transportation sectors. Sharon has been providing practical advice on implementing environment, social, and governance principles, practices, and reporting, and Indigenous community relations for decades. She has a reputation for her ability to progress issues through creating trusting relationships between industry groups, associations, governments, Indigenous and local communities and the not-for-profit sector. When you hear her and you listen to her, you can understand how she can get to that trust. She's also a member of the Canadian Bar, an executive of the Aboriginal Law section of the British Columbia chapter. She's recognized as a leading lawyer in the Legal 500 Canada and Chambers Canada, and is a Business in Vancouver's 40 under 40 recipient. That's extremely prestigious. She has many other awards as well, and well-deserved. Our final panel member is Mr. Ian Thompson, who has more than 40 years of experience in the mining industry, working the last 2 decades to advance and refine the management of social issues and resource development projects. He calls himself a social practitioner, and you'll understand why when you hear him. He has led development of new standards and guidelines for good practice, facilitated construction of principles and guidance for responsible exploration for the Prospector Developer Association of Canada, and been a prime mover in developing both the concept and metrics of the social license to operate. And you may also know, if you're familiar with PDAC, Prospector Developer Association, the E3+, that's Ian behind that. So welcome to our panel members. And let's come over here. I think our next slide will be our introduction to our first panel member. Can we go to the next slide, please? And I'll hand it over now to our keynote speaker and welcome the core. Sherry, thank you.
Thank you, Joe, for the kind introduction. And I want to thank the Center for Business Law at UBC, Transparency International Canada, and the International Center for Criminal Law Reform and Criminal Justice Policy for this opportunity to raise awareness of CORE's mandate and the processes established to implement it, and its relation, of course, to ESG and the linkages to corruption. The Government of Canada created the Office of the Canadian Ombudsperson for Responsible Enterprise, or the CORE as we refer to it, after almost 2 decades of consultations among the mining and oil and gas sectors, civil society organizations, and the federal government. Various Canadian governments were concerned about our international reputation if and when the operations of Canadian companies abroad caused harm to local actors. Canadian civil society organizations wanted the government to establish a body to monitor companies and provide a mechanism to resolve disputes and provide remedies for those harmed. The interests of the 2 extractive industries were, of course, central to the conversation, both in terms of operational governance and in terms of the impact on the potential economic benefits to Canada and in the countries they worked in abroad. In 2009, the Rana Plaza collapse in Bangladesh led to an increased awareness of human rights issues in the garment industry. And as a result, this sector was added to CORE's mandate. For the moment, CORE only has jurisdiction over the mining, oil and gas, and garment sectors. In the balance of my remarks, when I refer to Canadian companies, I will not repeat the names of these 3 sectors, but please note that they are implied. Previous mechanisms to monitor, support, and hold Canadian extractive companies operating abroad accountable were criticized for lacking the mandate, independence, and funding necessary to fully meet Canada's international commitments to promote and protect human rights. In response, the Government of Canada provided CORE with more tools and resources. These tools are set out in our mandate and operationalized by our complaint mechanism, which we call the Human Rights Responsibility Mechanism, or the HRRM. My presentation today provides an overview of our mandate and the complaint mechanism. Next slide, please. So the Canadian the Office of the CORE is a non-judicial dispute resolution mechanism. We represent the public interest in respecting human rights in the operations abroad of Canadian companies. And as an impartial ombud, CORE does not represent the complainant or the Canadian company. We work with both parties to try to resolve problems informally, or if necessary, we will investigate a complaint and where appropriate, will make recommendations to remedy a human rights abuse. Our mandate has 4 components: to promote, advise, review, and recommend. Next slide, please. The first component is to promote the implementation of the UN Guiding Principles on Business and Human Rights and the Organization for Economic Cooperation and Development, or the OECD, guidelines for multinational enterprises with our stakeholders. CORE's stakeholders are public, private, and plural. Our public stakeholders include government institutions and bodies, both domestic and foreign. Our private stakeholders include Canadian companies, sector associations, business associations, professional associations, among others. And our plural stakeholders include civil society organizations and academics. Next slide, please. The second component of our mandate is to advise Canadian companies operating abroad on best practices related to responsible business conduct. Responsible business conduct is about doing business abroad responsibly in an environmentally, so there's your E, and socially, the S, sustainable manner. It also means demonstrating respect for human rights and being consistent with applicable laws and, for the core, internationally recognized standards. That is, demonstrating good project and operational, and here's the G, governance. A Canadian company means an entity incorporated or otherwise formed in Canada with operations abroad. Next slide, please. The third component of our mandate is to review allegations of human rights abuses arising from Canadian company operations abroad. Allegations or complaints can be made by or on behalf of an individual, an organization, or a community. CORE's mandate includes the jurisdiction to review alleged human rights abuses perpetrated by a contractor or subcontractor of a Canadian company operating abroad. As such, Canadian companies are responsible to ensure that human rights are respected throughout the supply chain. Next slide, please. So what is a human rights abuse? It's the center of, and I want to just sort of point out here is that CORE only has a mandate to look at human rights abuses and not at corruption. So just there's, we can talk about in the Q&A, there's a linkage between, often a linkage between corruption leading to a human rights abuse, but we are focused only on human rights abuses. And a human rights includes rights related to the environment, labor, health, and safety. It means an adverse impact on an internationally recognized human right arising from a Canadian company's operations abroad, including any of the human rights that are referred to in the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, the United Nations Declaration on the Rights of Indigenous Peoples, among others. Human rights abuses can arise in a wide range of matters, including occupational health and safety, access to land, and employment practices such as fair wages and reasonable hours of work, sexual harassment, human trafficking, and modern slavery. I'd like to give a hypothetical example of what we might cover at the CORE, I have jurisdiction over. All three sectors under our mandate use chemicals in their operations. So one can imagine situations in any of those three sectors where these chemicals contaminate a local water source. This has an environmental impact as well as a human rights impact. That is, the local population's right to health is infringed. Further, if the garment industry workers are primarily women or the mining workers are primarily Indigenous peoples, the shutting down of the company's operation because of the contamination of the water may disproportionately affect those groups and their human right to a livelihood. In the oil and gas and mining industries, operations are frequently in remote areas, which often means that they're on Indigenous lands. And if an environmental issue arises due to these operations and done so without interaction and input from local community representatives from the Indigenous peoples themselves, it can quickly become a social, environmental, and governance crisis. Next slide, please. The fourth and final component of our mandate is to make recommendations. With respect to recommending remedies, to those harmed by Canadian companies operating abroad, we have several options at our disposal, including to direct the company to provide financial compensation to the person harmed and issue an apology, perhaps. With respect to policy reform, the CORE can make specific recommendations to reform corporate policies and also Government of Canada policies. And I will talk about trade measures in the next slide. So moving to the next slide, please. And I want to talk about leverage through investment. Financial support and investment are key to helping Canadian companies grow their business and access new international opportunities. In providing these services to companies, financial institutions can be connected to human rights related risks and have an important role in identifying, preventing, and addressing risks. When impacts are identified or occur, financial institutions, we believe, should have the leverage to suspend, reduce, or remove support. In addition, with respect to reviews by CORE, I, as the Ombud, can recommend a number of trade measures to the Minister of International Trade, including the withdrawal or denial of trade advocacy support provided to a Canadian company by the Government of Canada, the refusal to provide future trade advocacy support to the Canadian company, and the refusal by Export Development Canada to provide future financial support to the Canadian company. So we do have some financial leverage within our current mandate. Next slide, please. I would now like to provide the brief overview of CORE's Human Rights Responsibility Mechanism. It's our complaints portal. The HRM includes all aspects of how complaints and other inquiries can be submitted, how we assess them to see if they fall within our mandate, and how best to handle them. It also includes our processes for handling complaints, including through mediation, joint or independent fact-finding, and other practices like information sharing, dialogue, and facilitated negotiation. It also includes all aspects of how we develop recommendations, report and follow up on complaints and other inquiries. The complaint portal, I'm pleased to announce, was launched in March last month, and we're now accepting complaints. Next slide, please. The HRM is the product of extensive research and consultations with our public, private, and plural stakeholders. The consultations have been essential to help us to develop processes that are predictable, fair, and transparent, that take into consideration the circumstances of the communities, individuals, and companies that we interact with so that we can most effectively deliver on our mandate. A major reason why stakeholder consultations were so important is that the Order in Council that establishes our mandate provides little guidance on how we should operate. In developing the HRM, we drew heavily on the effectiveness criteria of the UN Guiding Principles for Business and Human Rights, specifically set out in Article 31. As well, the HRM is evidence-based. In addition to extensive consultations, we conducted significant research on all aspects of the HRM to reach decisions based on best practices that are appropriate to the on-the-ground realities of Canadian companies operating abroad. This included GBA+, racial equity, and other considerations about the kinds of power imbalances that occur in these contexts and how we can navigate through our processes. We developed operating procedures which provide the framework for how the HRM will operate in practice. Those are on our website, and my website address is at the end of the presentation. And finally, an important feature of the HRM is that we view it as part of a continuous improvement process. Next slide, please. A little bit about when we receive a complaint. When we receive it, we review it to see if it was within our mandate. And there are 3 criteria that help us make this assessment. And we refer to this as our admissibility criteria. First, the complaint needs to be about an alleged abuse of an internationally recognized human right, which is quite broad. Second, complaints need to be about an alleged abuse involving a Canadian company. So it has to be a Canadian company operating abroad. And third, complaints need to be about an alleged abuse that occurred after May 1, 2019, the day that the office was open, or if it occurred before, that the abuse needs to be ongoing at the time of submitting the complaint. If it is clearly not within our mandate, we will try to refer the individual community or organization somewhere else. We also have the ability to initiate our own review of alleged human rights abuses and have developed criteria and a process to help us to assess and prioritize the human rights abuses we will focus on in an Ombud initiated review in an objective way. Those criteria are also on our website and you can check them out there. Next slide, please. So the Corps is mandated to develop different kinds of reports at different stages of the process. These include reports on initial assessment, interim reports as we're doing a review, reports on country visits, final reports, and follow-up reports. All of these reports are to be made public and will be posted on our website. Next slide, please. To conclude, the HRRM, our complaint process, contributes to improved respect for human rights by Canadian companies operating abroad in three main ways. First, it provides access to remedy for those impacted by the operations of Canadian companies abroad. But importantly, it provides access to remedy through processes that are predictable, fair, transparent, and accessible, providing a legitimate option for all parties to address challenges that arise. Second, the HRRM provides access to mechanisms that can help the parties involved to find mutually acceptable solutions for themselves. We do this through mediation, but also through other collaborative processes such as joint fact-finding. And third, recommendations and other findings that may emerge from the HRRM processes are intended to provide concrete solutions to improve respect for human rights by Canadian companies abroad. This could include recommendations to companies, but also recommendations to the Minister of International Trade, for example, to review Canadian policies relevant to responsible business conduct. Thank you, and I look forward to hearing the other panelists and to responding to your questions.
Thank you very much. Thank you, Sherry. Thank you to IT Canada. Thank you to ICLR, and of course to the Center for Business Law. I really appreciate the invitation to be here. It's always a pleasure first to be with old colleagues such as Joe and Sharon. We've been in many panels together, and of course to meet Sherry as well as Ian. Next slides, please. So I wanted to start off with just talking a little bit about ESG and sort of bringing in the linkages that Sherry has brought, but bringing it in sort of from a big picture perspective. First of all, what is ESG? Everybody knows it's environmental social governance. What does it actually stand for? These are some of the considerations that are within the umbrella of ESG. And we can see, of course, it's the environmental. So for example, climate change, that's where you're going to see environmental issues. Social, we see specifically human rights. And of course, governance, that's where we see business ethics and anti-corruption. Now, the first comment that is critical in looking at this is that this is, of course, a fallacy. The idea that any of these issues are by themselves independent and not completely interlinked and interwoven with each other is not correct. They are, of course, interlinked and interwoven. And the question, though, is how they are treated. And it's just a way of ensuring sort of different classes of issues and different areas of consideration. But ultimately, please do recall that they are not separate and distinct, and they each have very much knock-on effects and interlinkages with each other. Can we go to the next slide, please? Now, one of the important things about ESG is that sometimes we have a tendency to look at ESG very much from the investor's perspective. And this is ultimately what I'm going to be focusing on. But I wanted to note that ESG is it's not only and completely an investor world. ESG is, as we saw, a category of issues and concerns, and it is viewed by a number of different parties in different ways and used by different parties in different ways. And therefore, how companies embed ESG issues are one way of looking at ESG, and of course how it then knocks on and affects the supply chain, for example, and how supply chain then embeds ESG issues within their parameters is different. And then of course, if we look at one example, and it has been quite a big push in the ESG agenda, is of course the final clients and final consumers, and how they are pushing as well an ESG agenda, and how important it actually is for the future. If we can move on to the next one, please. Now, I want to spend a little bit of time here because we've seen what is included within ESG, and we've seen that there are a number of players within the ESG parameter and ESG world, but ultimately, what is it, right? Investors use it as a decision-making tool. They take ESG parameters and they score companies against them. So there is a sustainability premium depending on your ESG ratings. That is, of course, ESG, part of the ESG component is our disclosure parameters. And I'm going to talk a little bit about those, but we could define them as merely being disclosure parameters, or even a compliance tool, or more specifically, and perhaps what has really been used is a risk mitigation tool. And those headings that we saw under E, under S, and under G are really risks. And the question is, how are companies and the supply chain and the corporate world managing these risks? And one could define it as that. But I would suggest to you there's something a little bit broader happening, because ultimately ESG has been and is an absolute tsunami. I think it's impossible for you to open the newspaper and not see something about ESG at least once a day. And so I think that one of the things that ESG is also, for example, being used for, it is ultimately the business case for stakeholder capitalism. And this may not be relevant for all jurisdictions, but for example, in the US, this is something that is very much being discussed, is this idea that if you are good at ESG, then your company will do better. And therefore that is a business case of being more attuned to ESG parameters. It's also been considered sort of the path to build back better. If we look at the build back better push, and we see this particularly with regards to governments and their way that they're going to trigger the economy to get out of a post-COVID-19 depression, recession that we're living in, then the ESG is very much a pathway to wellness and inclusivity, right? It includes all of this aspect of a better world that is built through taking into consideration ESG parameters. Now, I just want to bring your attention to Larry Fink's letter for 2021, in which I think for the last 3-4 years, he's put ESG front and center. This year, 2021, he has done so once again. But what I would like to say, and this is what I'm saying, that I think maybe there's something a little bit bigger going on, and the weight of being put on ESG, in which he actually says how optimistic he is for the future of capitalism. And he also mentions how he thinks that ultimately we're looking at a sustainable capitalism all through, I would suggest, an ESG framework. So ESG really is critical. At least today, it is the buzzword for those of us that have been working in especially in the extractive sectors. These principles have been around for a very long time, but ultimately this is what's happening now. Now let's talk about investors. And can we press the next? And let's just talk about what is ESG, what is the impact of ESG, especially with regards to financing. And we look, of course, that ESG, what is it impacting? The cost of capital and capital availability. So what companies are looking at is that their green capital or capital that is associated to ESG parameters, whether they are more available, whether they have access to that capital, will be impacted by their ESG ratings. Can we go to the next slide, please? So there's many ways to skin this cat, and I'm getting to why this is all important to mining, because this is it. So ultimately, if we look at ESG, and again, let's just look at this from the investor's perspective, what does it do and why is it important? First of all, it is exposure to risks and issues. It's a determination of whether these risks are actually relevant to your industry and to your company. mining, particularly mining, and all extractive industry, but particularly mining, has a very high exposure to these risks and issues. If we look at S&P 2019 analysis of industries, they determined that mining was the industry with the most amount of risk associated to ESG. And then the question is, how are these risks managed? And then it becomes a corporate issue of how the company manages these risks. How is this management undertaken of these risks? Through programs, policies, and procedures. How are these programs, policy, and procedures advised or shared with the world? Through disclosure and transparency requirements. And then when we look at this sort of framework, we look at a number of inputs that come in. So we look at ESG rating companies, for example, that will look at the programs, policies, procedures, and disclosure requirements, and then compare them between companies. And then of course, we'll look at international framework and standards and how they apply to the industry or to that company. There's been a lot of choice and too many, and I think Ian is going to talk about this as well, but ultimately there's a lot of frameworks and standards that apply and how they are relevant. But ultimately, if we look at what ESG does and how it is being used, I would suggest to you that this is a simple way of understanding how ESG matters and how then ESG rating companies are used. And if we look at investment funds, they will use ESG rating companies as part of their decision-making process to determine where they're going to invest. If we can go to the next slide, please. So these are some, so I don't want to go into a lot of details, but these are some of the ESG standards and performance indicators and industry standards and performance indicators. So I just wanted to mention that, first of all, if we look at BlackRock, and I said they have, I want to make them, I'm sure I give you the right number. It's 8.67 trillion US dollar is in assets under management. They have specifically stated that to follow SASB, which is the Sustainable Accounting Standards Board, as well as the Task Force on Climate-Related Financial Disclosure. And here we see industry is really, capital is really trying to focus industries within specific standards and frameworks that are comparable against companies, because ultimately one of the problems is there's so many standards and so many different performance indices that it's very difficult to compare oranges to oranges, apples to apples. So we're seeing a real effort here to try and push as much as possible some sort of universal standard so that everybody knows what is being disclosed and how it's being disclosed and what are the targets that are being disclosed. If we look as well, in last year, November, we had eight of the largest Canadian pension funds, as well as CEOs, also supporting SASB as well as TCFD as their parameters. So if you look at SASB and their disclosure parameters, they have specific disclosure topics, and they have those divided into environmental, social capital, and then human capital, and then leadership and governance. In their leadership and governance provisions, they include business ethics, and transparency. And in their social capital, they include security, human rights, and rights of Indigenous peoples. And then human capital, they include labor relations and health and safety. And this is just to give you an example. Now let's look a little bit further, and I should mention that there are industry-specific standards. And if we look at mining, we have SASB has Metals and Mining Sustainability Accounting Standard, which is specific to the industry. The GRI, which is also one of the most important reporting indicators, has a mining and metals sectors disclosure. ICMM, the International Council on Mining and Metals, also has very specific industry-specific standards and frameworks, and the Initiative for Responsible Mining Assurance as well. Now, I just want to touch base on SASB for a minute, because SASB has, they just recently had a presentation with the Toronto Stock Exchange, and I wanted to share with you some of their numbers and what they were looking at. So They have under their umbrella 29 mining companies that have that are supporting SASB, and ultimately, and 15 of those are within the mining sector. Sorry, 15 of those are within the Canadian mining sector. Can we go to the next slide, please? So 15, as SASB said, there are 963 juniors and 202 majors listed in the Toronto Stock Exchange. Not sure how we're doing on that. And then I'm not sure how the mining industry is actually, one would suggest that majors are adapting more and more to very much to the ESG platform and ESG issues. But I think that it'd be fair to say that we have a long way to go. I'd just like to go to the next slide, please. I just wanted to mention that ultimately ESG relates to both projects, operations, and there's always an M&A component to it. If we can go to the next slide. I just want to finish off with one little reality check. Now, I've taken Vale and Rio Tinto's ADRs that they are listed in the New York Stock Exchange, and I just wanted to show you that, as you know, Vale had a tailings dams breach of Brumadinho where there are more than 270 deaths. And this was a consequence to their share price when that happened. This is when Rio Tinto exploded the gorge in Western Australia, which was 46,000-year-old and with a direct linkage to Indigenous peoples to 4,000 years old. And this is that aspect to it. My last comments on this is this. I would suggest to you that in mining, the investor is actually very used to and aware of these risks. And because these risks are not new, they have been in mining since mining has begun. However, what I think that is going to happen is that the resilience of investors within the mining industry is going to change, because what we're going to see and what we're seeing right now is the biggest generational shift of wealth that has occurred in history. And we're moving from baby boomers, profit seekers, very much perhaps unfamiliar and not as prone to considerations of ESG, to millennials who are much more ESG focused and ESG concerned. And the question is, when we look at the actual facts, how is the industry really going to make the change? Are they making it? And is ESG the right platform to do so? So those are my comments. Thank you very much.
I think it's my turn to speak, if I'm not mistaken, or is Joe Ringwald on mute?
Carry on, Sharon. Thanks.
You know, I did a presentation yesterday, rather moderating a panel, Joe, and I did achieve a world record. I had no mute occurrences, so I was very proud of myself, just so you're aware. Let me start by sharing my thoughts on ESG more broadly, and I promise, hopefully, not to repeat any of the more eloquently put considerations highlighted by Daniela and Sherry. And as Joe Ringwald will tell you and provide you ample examples of, is that although anti-corruption is related to issues more typically associated with governance, the environmental and social considerations often provide the red flags of an underlying or apparent issue. The point was underscored by Sherry in her apt example of what may be classified as human rights abuses. And I'm going to pull from some of the points that my colleagues and I shared recently in our ESG series, which you can find on the Bennett Jones website. It's far more comprehensive. From a legal perspective, the framework in many jurisdictions, especially in Canada, has been evolving over decades. Although that evolution has occurred more rapidly recently, the frameworks do support decision-making processes that consider impacts to stakeholders and rights holders beyond just the shareholder. And Daniela highlighted this as well. These impacts include impacts to Indigenous communities, employees of organizations, and the environment, based on a broader view of what is in the best interest of a corporation. You saw the very helpful slide from Daniela, and I am on slide 2 right now. You saw the very helpful slide from Daniela highlighting the different pillars of ESG and what fits into each bucket, so to speak. And from my perspective, much of the discourse around ESG, especially at the institutional investor level, has tended to focus on risk mitigation, particularly as it relates to the environment. And Larry Fink's letter is a good example of that. But there are other opportunities associated with ESG that are often, left in the sidelines because the focus is on just risk mitigation. And we don't have time to delve into that. I'm sure we can set up different panels to discuss that in more detail. And so the focus on environment, the first pillar, has meant that most organizations have really ramped up their discourse around carbon footprint, becoming more environmentally sustainable, pledging to go carbon neutral or even carbon negative. And Earth Day examples, the abundant amount of them this year has provided has illustrated what I'm trying to say here. From my experience, though, the conversations around S&G have not received the same level of considerations, including amongst the frameworks that Daniela had highlighted, or the standards. And often, the one sector that has had a lot of discourse around social and governance and has been at the forefront of actually putting in place voluntary and meeting those voluntary standards is the natural resource sector, the extractive sector, where issues relating to Indigenous communities, employees, and governance has been in the media, and as most of you know, strangers to, source of public and policy debates. And for me, the social and governance are the driving force behind environmental performance. But yet the performance standards related to these are the ones that are lagging more substantially. And I think one reason for that is that S&G factors are harder to assess. The metrics around them may be subjective and they're multifaceted, so they're harder to tackle. So one area to watch out for growth in is in the standards and the frameworks that are out there, the plethora of them, is the growth of what specific performance criteria will go towards S&G and how you actually monitor it, how do you actually report on it, and some sort of standardization happening in that. And as Daniela said, and I couldn't agree with her even anymore, the 3 pillars of ESG are intrinsically linked. There is, although we might have these 3 pillars, they each affects the other. And one can take one aspect and really fit into either bucket depending on how you cut and parcel it. So to summarize my point on this particular slide, ESG awareness definitely has accelerated. I think it's accelerated more than COVID has. And I think although the conversation has been around E, the S&G will surely follow in areas apart from just the extractive sector. The awareness, however, does create scrutiny, it does create pressure, and importantly, it will require, because governments only respond to pressure and public outrage, actions by governments and by organizations. So on to my next slide, which, and my slides are really to guide my discussion, because otherwise I will ramble on. It's about the frameworks, reporting, and due diligence. And one thing that ESG really, when we talk about it, the emphasis typically is on the frameworks and standards and reporting. Why is that? And why is it at the heart of demonstrating ESG performance for many? I think because it creates an opportunity for organizations to tell their story. This is how they can be proactive and shape their own narrative and enhance their ability to attract institutional investment or public support. Done earnestly, I truly believe that ESG reporting can be a way to engage stakeholders and right holders to create a path forward of mutual benefit. But there are also a lot of challenges with such disclosure and such reporting, including related to standardization and accuracy. Verifying statements to ensure that what you're reading when someone puts out a sustainability report is actually what's happening on the ground. It's not misleading. The frameworks that companies say that they're following or reflecting in their practice are actually the practices on the ground. It's not to say that all companies are lying. It's that often in an effort to win the public battle on this, you read something very superficially and say, yeah, of course we're meeting best practices when it comes to environment. We do X, Y, and Z, but there's more to it. And right now, the resources aren't there except for the public to actually verify whether these statements are being met, or investors, frankly, because it is a litigation risk if you're claiming something and you're not meeting it. And I think, part of it, and I touched on this a little earlier, is that because these standards are for the most part, the reporting is most, frankly, voluntary, and there is not yet standardization on the multitude of frameworks that exist. And SASB and GRI recently had stated that they're collaborating. Hopefully that will provide a little bit more uptake on both, and you're not having to choose, but they also do complement each other as well. I'll give you examples. SASB, they create industry-specific standards. So there's one for mining. You go down further, and there's one for coal. The and they really look at sustainability-related risks. Although they say they look at opportunities, in my review, I didn't find many. The GRI typically focuses, again, on the economic environment and the social impacts, but again, it goes back towards how does it contribute for sustainable development. So I think this is an area to definitely watch for. And when I say that, in my slide, the point I'm trying to make is these reporting and these frameworks are great. That's what most, much of the discourse outside of the extractive sector has focused on is really, take this up, and it is what ESG is. But for me, it does not displace the due diligence that has to be done by companies, for instance, looking to take over assets, by investors, by the public, and by governments. An example is when you take over an asset, it might have the most atrocious human rights abuses, and the company that's taken it over is really focused on cleaning it up. But that will not be reflected in any of the reporting that is done based on these standards and the frameworks. And if, for example, these frameworks and standards and could displace the requirement to do diligence, I don't think you would need Sherry's office. So there's a reason why we have the core. And that's I think underpinned by why we still need diligence. And I want to touch on another point, and I truly believe this. Although there's many examples of the mining industry, there are bad actors in the mining industry, and to some degree forestry has been at the forefront of establishing standards. TSM is an example, and following them and reporting earnestly and transparently on these aspects. That's not to say, everybody get a free pass, but that's just to say that although some of them may not take up the reporting houses, that's not to say that, they are laggards in that sense. I do think the big ones anyways are actually leaders in this space, and they will make mistakes. And Jukin was one example of that, but it doesn't underline the much good work that's been done. And I'm supposed to be talking about Indigenous communities, so perhaps I can go to the next slide, which Indigenous communities, again, this is a pet peeve of mine. So if I take longer, I apologize. They're typically, in all the discourse, and again, Daniela highlighted this point, they're typically bucketed into the S. But for me, I live and breathe the space. Indigenous communities and they're significant contributors to all three: the environment, social, and governance. And it depends on how you look at it. On social, of course, you're looking at the relationship aspect of it. It's social license to operate focused, as typically that phrase is used. It's looking at whether you have the support of the community, and now more often the discussions whether you have consent. And you are in Canada seeing a move away from pure consultation to collaboration and partnerships. That's reflected in legislation such as the Impact Assessment Act, the Environmental Assessment Act in British Columbia, and you're seeing that filter through down to the Mining Act, for instance. And Indigenous communities, it's not just about the consent aspect of the other regulatory legislations, really looking at how do you incorporate Indigenous traditional knowledge into decision making? How do you increase participation of these communities so as rights holders to be able to have that self-determination and have that self-government? So in terms of when we look at E for Indigenous communities, the traditional knowledge, the protection of the environment, the Indigenous communities are very much at the forefront of that. And, you know, as Danielle highlighted, it's intrinsically linked. On governance, you look at board representation. I think CN just recently announced an advisory committee that will advise the board made up of Indigenous representatives and high-profile ones like Senator Sinclair. You look at Indigenous factors as they relate to D&I or human rights legislation, such as accommodating Indigenous employees. So for me, Indigenous factors, and I say that because I can't find a better word right now, really pose an underutilized discussion, too often siloed at the social license operate bucket. And this is a nuanced point, but Indigenous communities are not static in terms of their position that they have in resource development or in discussions around ESG. They're not just the recipients of information, rather more and more they're the proponents, and they're the providers of the information or the actual actors undertaking the steps that we were talking about. And you know, there's a difference between Indigenous communities as proponents, Indigenous peoples as proponents, and Indigenous communities as rights holders that can be utilized by Indigenous proponents to fulfill their obligations under Constitution. So let me just pivot a little bit after making that distinction to UNDRIP, and that's the focus of my next slide, I believe. As UNDRIP will be known to a lot of you, and excuse me if I repeat a little bit of this, but essentially it's 46 articles to declare standards for the rights of Indigenous peoples around the world. It was adopted in September of 2007 by the General Assembly. It's important to note that it's a declaration, it's not a treaty or a convention. And the text of UNDRIP, I may just misquote this, but it was proclaimed as a standard of achievement to be pursued in a spirit of partnership and mutual respect. So that's why, you know, when we talk about implementing UNDRIP, it requires extensive interpretation to say, how does UNDRIP actually reflect in the laws? How do they touch on the how do our laws currently touch on the subject areas, which are broad? And how do we need to change public government policy and legislation such that we implement UNDRIP? To give you an example, some of the articles in UNDRIP include the right to freedom from any discrimination, which is, you know, something that we can all agree on is pretty standard in terms of what we can expect. The right to self-determination, really determine political status and freely pursue economic, social, and cultural development. So what is freeing in that instance? And that's why lawyers, you know, have a heyday when they're talking about UNDRIP, because everybody has a different interpretation and a different lens. Again, Joe Ringwald will tell you about lenses that we all put on our interpretation of these things. Indigenous people under UNDRIP have a right to self-government relating to their internal and local affairs. That includes citizenship. They have the right to the conservation and protection of environment and productive capacity of their lands and territories. And again, I want to highlight that point and touch back on what Sherry said in slide 5 of hers to say why that's important from a human rights perspective. And of course, the more often discussed area of UNDRIP is the free, prior, and informed consent aspect. And that's referenced throughout in UNDRIP, including before states adopt and implement legislative or administrative measures, before before governments approve any project affecting their lands and resources. So what UNDRIP actually does is it underlines the Indigenous rights to protect their culture, their identity, their religion, the language, the health, the education, the community, and all of that including the environment as broadly defined. So what is the state of play of UNDRIP in Canada? BC, where I'm currently speaking to you from, we have passed legislation back in November 2019 to implement UNDRIP. The legislation requires BC to align its laws with the declaration. This is alignment is obviously something that's going to take a very long period of time. The deputy minister and the minister, when they were consulting on this, you know, acknowledged it's going to be a generational long exercise, and that I think is the only way that one can actually align the laws of British Columbia with the declaration. It can't be done overnight. That's not fair to Indigenous peoples who cannot be consulted on what that looks like, and the public more broadly. Federally, there is a bill before Parliament right now that looks to essentially replicate what BC did. And if some of you have been following this, it's similar to Bill 262. That was a private member's bill that failed, that died on the order paper in Senate. The bill right now has passed second reading, and I think it's before the committee stage, but it's very similar to that of BC. Again, it requires the government of Canada to take all measures necessary to align the laws of Canada with that of UNDRIP. It requires them to prepare an action plan to be transparent about how they will achieve UNDRIP's objectives, and table a report on the alignment efforts and how that's proceeding. There are other more very relevant points, and I hope to get into that, so maybe some of the Q&As, in terms of what does that mean for the status of UNDRIP currently, if essentially these pieces of legislation are enabling such that you need to pass a subsequent piece of legislation to implement UNDRIP. And I'll give you an example: environmental assessment that is, according to government, is UNDRIP compliant because it has been aligned. But every single other law that is to be that exists right now may not be. And it'd be remiss of me, because everybody likes to talk about free, prior, and informed consent, to say, well, what is it? I can tell you my interpretation. I can tell you what the government's interpretation is, but I can tell you also that it's going to be played out in the courts. It will be contextual, is my take on it. And everybody will debate whether, although all governments and communities more and more are saying, Indigenous communities saying, FPIC is not about a veto. It is about achieving consensus. I think I can highlight two issues that come to mind. It might not be a veto, but Indigenous communities look at free, prior, and informed consent as more than as a process. But at the end of the day, it's underpinned by the fact, and let me back up a bit. Some Indigenous communities that I have spoken to, so I can't speak for any of them, but from my perspective, what I've heard is that it underpins the right that they have as rights holders. So it's not something that they're given, as they have a right to make free, prior, and informed decisions. So it might not be a veto, but what governments have not adequately answered is what happens when that process to achieve consensus fosters a no. We know that if there is a broader public good aspect of it, then it's likely that the no will be taken into account, for instance, in conditions, etc. But when we're looking at, I'll give you an example of Site C. How will that play out if it were to go out through the courts, if it did require the free, prior, and informed consent of Indigenous peoples? And I not to put a too fine a point on it, but current legislation, I believe, has been followed. That is, that you have sought to achieve consensus, and that consensus hasn't been obtained, but the legislation allows a minister to make a decision. So, but if in the future that was to change, where, for instance, the factors going into it, the minister has to take into account is whether FPIC has been achieved or not. Based on the process, there is a room for, I would say, argument whether the process has been followed. On to my last slide, which is the trends that we're seeing. And, I think it's not a surprise to the extractive sector that ESG is not just a nice to have. From a legal perspective, there are requirements that underpin a company's obligations as it relates to ESG performance. That's not just limited to the voluntary standards or frameworks that are out there. It includes directors' duties as espoused in our securities legislation, in our common law. It's also included in our environmental legislation and our occupational health and safety legislation. And so it truly is a big tent. Often, and I just want to wrap this up by providing, I guess, some of my commentary on CORE and some of the trends that are happening also in the community that I touched on earlier. We hear criticism that Canada has double standards. That is, we may have certain standards that we expect our companies to follow at home, and then we don't expect the same when they're operating abroad. And I think apart from the establishment of CORE, through its many manifestations, I think finally this is the CORE establishing a mandate does address this criticism. The government's also progressing, or at least not standing in the way of other calls to action to address social considerations that often, get put in the bucket, well, it's not in our backyard, and frankly, extracurricular jurisdiction, we can't do anything about it. They found ways, including, for instance, in the modern slavery bill, which there's been previous efforts, but again, have not passed. And if this bill passes, it will require entities, and entities is defined similar to what ESTIMA has defined entities, if any of you were following that discussion, whereby they will have to report publicly on the measures that they've taken to prevent or reduce the risk of labor or forced labor in their supply chain. So it also has, the bill also has the ability to restrict trades and imports of any goods or manufactured or produced. And I think it's one to watch out for, because other jurisdictions have it, we haven't. And although these are, these mandates that are, and bills that are increasingly getting more support, including one on environmental racism, they're great. I do want to give the sort of flip side as well, which is we can't be blind to the potential abuses that exist of these type of, I would say, legislations. Malicious claims will continue to be made. People have variety of lenses that they put on their variety of considerations. And that's why I think due process, procedural fairness, and ramifications for malicious claims has to be embedded in any issues that we speak of. CORE needs the resources to ensure that they have the ability to actually review the complaints that are made in earnest, not just from relying upon the submissions that are made. And on Indigenous communities, like I said earlier, a growing number of them are proponents. They're the investors of projects. So they too will have to meet the same ESG or, the performance standards that they are expecting of others. And again, when I say they, it's not a static they, there's different actors in the Indigenous communities that applies to. So for me, in summary, a key theme of ESG and where it really highlights the corruption angle is that ESG it underpins transparency, and it underpins transparency through collection of data, through reporting, which whether it's voluntary, whether it's through some frameworks, whether it's some standard, whether it's some reporting agency looking at you, it does promote accountability. And more institutions, including investors, regulatory agencies, are mandating that data be collected. So the bigger trend I see is the rise of reliable and accessible data to promote good behavior and address bad behavior, that which includes malicious and improper criticisms. That's probably where I'll leave it and pass it on to you, Joe or Ian.
Thank you. I will do my best to not ramble on too much. I'm one of the people who believes that this explosion of interest in ESG is potentially good news. It offers an awful lot. The question from my perspective is, can it actually deliver? Next slide, please. As has been pointed out, it has come out of investors, and they're asking three big questions around the environment, the social side of things, and around governance. This is a quote from Forbes magazine, so this is definitely the business side of things. And they sum this up as saying, the fundamental question is, how does the company serve its stakeholders, workers, communities, customers, shareholders, and environment? So that's a pretty holistic view, and certainly it's pretty invested, and it's pretty much integrated, and it's really talking about outcomes. So here, what is the consequence? Next slide, please. Given the leverage that comes from shareholders and investors, there really is an opportunity. The question then becomes, can the pressure for ES&G performance lead to better outcomes? Can it really do that? Can it deliver on better outcomes for communities and ecosystems affected by mining? And what is the mechanism for this? Well, Price Waterhouse in their materials suggests that ES&G disclosure and reporting provides a window on the company. This ability for outsiders to look in and get an understanding of what the company is up to. Next slide, please. So there is therefore an ideal situation which for the company that it can demonstrate its values, goals, and metrics to mitigate risks. And suddenly we're not talking about outcomes, now we're talking about risks. It can identify its strengths and weaknesses and offer a baseline. And for the investor, there are criteria available to evaluate the company and its operations and avoid companies that are prone to greater financial risk. So here we are, disclosure and reporting. We've moved from outcomes very quickly to talking about risks. Next slide, please. So the question then becomes risk to whom? We started off talking about outcomes for all stakeholders, but somehow we are now talking about risk to investors. So, what is this really starting to tell us? That there's really, a preferred stakeholder group. They have priority on this. It's their risk that takes precedence over other risks. So are there other risks to other stakeholders being overlooked or minimized in any way? The worrying thing here is that from a corporate point of view, if you're managing risks to investors, what you're really is worrying about the risk of losing these investors. So what are you going to be telling them? What risks are the company creating for other stakeholders that are not necessarily being disclosed to those stakeholders or communicated in their totality? So the challenges then become what is disclosed, what is reported, who discloses it, and in fact, for me at any rate, where is the accountability for these disclosures? Next slide, please. So what is disclosed and reported? Well, Price Waterhouse assure us that reporting follows commonly accepted standards known and trusted by stakeholders. Well, blow me, I think that that's actually a really aggressive statement, because where and what are these standards? For the environment, there is a strong regulatory underpinning, a foundation, and reasonable commonality from place to place around the world, based on this regulatory regime that's been around since the 1970s and the original environmental acts and laws that have come in. But on the social side, it is decidedly fragmented, incomplete regulatory foundation, no real communality there. Somewhat better for the internal stakeholders when it comes to labor and working conditions, health and safety than it is for the external stakeholders. But I have to acknowledge that there is a total plethora of guidance. In fact, probably far too much. The reality on the ground and the reality of these various guidances is that they're often highly context specific. The net result for the corporate side is total confusion. Who do I follow? What do I do? How do I know that I'm communicating the right thing to the right people? And in this case, the right people are overwhelmingly the investors. For governance, there is a very, very strong foundation at the corporate board level. But when it comes to the mining sector, is this enough given the very dispersed and devolved management structure that many companies have, giving tremendous amount of power, local authority to mine managers, regional managers, project managers? We really need to see something happening in that area as well. So next slide, please. what has been notable is that the securities regulators are taking notice of this interest from investors and the way in which companies are responding to this investor concern. And so they're moving to introduce ESG reporting requirements. They too are looking for relevant standards and guidance. And this has set up a veritable global scramble to fill the gaps. And particularly on the social side, I was party to a working group meeting a few weeks ago where there were representatives from 12 different countries all doing this. And what were they doing? Well, they were following one of two approaches, broadly speaking. They were either writing standards for performance, in other words, what their expectations of performance by mining companies would be, or guidance and instructions for reporting on risk factors. This was then very focused on the risk element and primarily risk to shareholders and investors, not necessarily to other, at least not in terms of focus. So that then brings us up to the next question, which is who writes the disclosure? Who reports on this? Because I think this really matters. At the moment, I have to say that we have to expect reporting to demonstrate compliance and beyond that, offer comfort or protection for the investor that we're doing better than complying. But what about the other communities? What about what sort of information is flowing to host communities and to other stakeholder groups? Indeed, often what information is flowing to the internal stakeholders within corporations? Next slide, please. In terms of accountability, I think we have to acknowledge that it's not possible to regulate good behavior, but you can reward it. You can certainly censure delinquency when things go wrong, but you have to be able to describe and define what the misdeed is, such as a failure to disclose a risk. That would be a misdeed. But what are these misdeeds? And this takes us back to the standards, but it then also asks who is qualified, who is competent to make that judgment. And at the moment, there is no equivalent of the qualified person, the geological engineer or the geologist, the qualified, the QP person who signs off on technical reports on reserves and resources for a National Instrument 43-101, for instance. There's no equivalent for environmental and social. And with this emphasis on risk right now, it seems to be sliding towards the lawyers and the big accounting firms to say, oh, we can do this for you if they're approaching companies. And certainly recent events in the USA say that perhaps only these lawyers and large accounting firms can get the professional insurance to sit behind them. So the big question then becomes where and who are the subject experts, the relevant qualified persons for matters environmental and social. Next slide, please. So which will take me up to my final point. I want to be quick so that we can have some real discussions. My concern is that the weak framework for, or the lack of, a true body of internationally accepted standards is currently a limitation. I think that reporting selectively addressed to shareholders and investors is a problem. When and how do host communities get to look through the window into the company and see how it manages risks to them? I think the view of governments is also limited. This focus on the board and corporate affairs fails to address issues, the real issues around what is corporate culture, what is that corporate culture like? And it doesn't deal with the reality of the mining sector. There is so much devolved responsibility to mine managers and project managers at exploration projects. Then finally, where is the reliability? Where is the competence? Where is the accountability in the absence of input and the presence in all of this of genuine subject experts in matters environmental and social? And with that, I will conclude. Thank you very much.
Thank you, panel. Lots of information, lots of things to absorb. We're going to move into a Q&A period now. And so I'll ask all the panel to turn on your video, and you can activate your microphones as necessary. This is interesting that I'm getting a screen activation from Ian. I don't know if this is in filling the screen as opposed to just a video at the top of the screen.
I should be on. I can't understand why I'm not.
Okay. So during the presentations, I don't know if the panel members had been reviewing the chat room, but we've been getting a flood of questions and comments. And we have about a half an hour before we have to wrap up. And we're gonna get through some questions. And I think it'll be a challenge to get through a lot. And we'll try to address some of the questions from certain individuals. And whereas some people have thrown in multiple questions, we'll try to get to at least one from each. But this will be a challenge. Right now, I think I've got 3 pages of questions here. So what we're gonna do is just start with something simple. That it goes to the core of why we're putting on this event through the ACLP. And that is, what is the relationship between ESG, human rights, and corruption? How are they linked? So I'm gonna throw that out to the entire panel. Somebody wanna jump in first?
So I can start off. I have a few comments on this. So as I mentioned in my presentation, all 3 ESG factors are linked, but human rights and corruption are especially linked. And I just want to make sure that I remind everybody that on June 17th, 2020, the United Nations Working Group on Business and Human Rights actually put out a report specifically highlighting the linkages between corruption and human rights, and the fact that in many cases, corrupt activity may lead to human rights violations. And arising from that, they actually came up with a number of suggestions. And I think that this is particularly important for this seminar. So, and these suggestions are first and foremost, and this is, you know, I've worked in a number of companies, but the way that things used to work is that things used to be very much in silos. You had human rights experts, and then you had your anti-corruption experts. And one of the biggest things is to ensure that these two are actually linked together even from a business corporate perspective. But what they suggest is also that linkages should be done with regards to government incentives and what government action is. So one of the suggestions that comes out from the working group is that when we are looking to anti-corruption and institutions such as the court, for example, which looks at human rights, but then there ought to be also always a linkage associated to the other one. So if it's human rights associated to corruption, and if it's corruption and associated to human rights. Just so sort of some of the broad thoughts on how those are linked.
Thank you. Can anybody, and I'm going to ask Sherry to chime in on this, but I'm going to add a little bit more for Sherry. Through TI Canada and I guess through the legal community, there's recommendations for companies to have an anti-corruption program or policy at least posted. Without that, and addressing the question of the relationship, is it even possible for a company to have a positive ESG rating? So Sherry, can you chime in?
Sorry, I was sort of focused on what Daniela had said and what I wanted to jump in there. So I'm going to have to ask you to repeat that in a second. But what I wanted to sort of jump in on to follow up on Daniela was that, you know, the core in our mandate actually anticipates that there could be it could be where an issue is solely corruption, and in which case our mandate, you know, anticipates that we would refer that to regulatory bodies and to, you know, to other bodies that deal with criminal matters, because corruption is criminal. But it's also within that you could have a matter that is corruption that has created, or, you know, human rights, and then that we would be able to deal with the human rights aspect of that issue and another body could be dealing with the criminal aspect or the corruption aspect. So while we only do human rights, there is going to be coordination, and we are already in the process of making those connections with these different bodies and making sure that we are able to, we know in advance how we're going to work on those together.
You, okay, so that also, I guess, addresses that linkage between them. You're going to throw that back out to the rest of the panel. Anyone want to comment about the link between human rights, corruption, and ESG? And is it even possible to get a positive rating if companies are not addressing this ESG issue and corruption? Okay. We're going to move on then. Can leave that question standing there for the audience in general to consider that, whether or not a company can move forward, particularly in light, as Daniela said, even with the share price issues with Vale and Rio. There's a question for Sherry. I'm kind of curious about this as well. We got it from one of our observers. What other countries have mechanisms like CORE? And how does Canada approach addressing business and human rights allegations compared to the approach in other countries? How do we fit into that overall global model?
Yeah, thanks for the question. So the CORE is, it's a new innovation. It's different from what exists in other countries. And, you know, we'll be further expanding that. There are national contact points under the OECD guidelines. Of course, the OECD guidelines, you know, only one chapter is focused on human rights. It does deal with also corruption, so it's broader. It has all sectors. But, you know, those bodies, although NCPs around the world govern themselves a little bit differently, and some of them have stretched their mandates, the mandate of the CORE is much more extensive. We have more tools than the Canadian NCP and most NCPs around the world. So, and by that, I would just, you know, identify some of, we can do joint fact finding. We can do mediation, which the NCPs can do, national contact points under the OECD, but we can also do joint fact finding. We can do independent fact finding. Most importantly, I believe, is because we are guided by the UN guiding principles on business and human rights, we are focused on remedy. And so we are going to look at the issue. We're going to, whether we mediate or we do an investigation, we are going to make recommendations on how to address the harm. And let me just point out, you could be as diligent as you want to be as a company, and you could still, harm could arise. We know that, you know, from things here in Canada. So I think that's an important aspect of how we're different, and that does emanate from the guiding principles on business and human rights.
Thank you. I'm going to throw this out towards Sharon and Daniela. See who hits the unmute button first. Is there an appetite among institutional investors to proactively advocate for regulations that promote ESG values through collective action, as opposed to being passive and just receive and review ESG reports from companies?
I'll keep it short because I didn't keep my presentation short, guys. Yes, there is. There is, because they're the ones pushing for it, and they're at the tables, including the pension funds, creating their guidelines, not just calling for more collaboration, but speaking with government. So often in the roundtables that I am involved in, they're at the table. So there is an appetite there. It's a tool for them to look at opportunities. Also, as the focus has been risk, as manage their risks. So they're just not passive in this discussion. Some may be, but the bigger ones are definitely not.
Yeah, I just wanted to say that I agree 100% with Sharon. I would not say that investors, especially not large institutional investors, are passive with regards to this. I think that perhaps one of the issues, and I think that Ian really put his finger on it, is one thing we're talking about standards and frameworks, and very much a pick and choose what is going to apply to us, to the industry. The other thing is actual hard law and regulations, which then reflect on accountability and what happens when you don't actually follow those sort of standards. And I think that is the question, I think, is not only investors, but for example, what is the role of government with regards to ESG and regulating ESG and that regulating this environment? Because what we have seen is that this continues to be very much within a voluntary world, right? We are seeing hardening. We're seeing a lot of, for example, litigation associated to ESG factors. And so that is a push to how companies are acting. But ultimately, I think that the big issue is, where is government, and is regulation, the hardening of this, going to actually happen in the next 10 years?
Thank you. Ian, I'm going to throw something at you.
Okay.
Just kind of share the wealth here. Is ESG the new CSR?
Whoa,
and if they are different, how?
Well, many people would suggest that it is an evolution from CSR to ES and G, and a hardening of the reality associated with all of this. CSR is corporate social responsibility. It is something nice to do. It is, a benefit. It helps. It's a feel-good sort of thing. The ESG is somewhat more comprehensive. It is got labels associated with it: environment, social, governance. Yeah, it's hardening out. So it is a maturing of this evolution of the, a broadening of the understanding of what is the role of the corporation. To me, it's, in a sense, it's North America coming in line with Europe, who have been thinking this way for quite a lot longer than North America has. And it is perhaps, finally some softening of the neoliberal approach, which says the corporation is king, profits is all that really counts, the primacy of the shareholder and all those other things. Yeah, hopefully it's good news for all stakeholders. Yes.
Thanks. I'm going to question for effectively the entire panel and chime in. We're seeing, particularly in the past few months, there's a number of panels and events relating and focused on ESG issues. We know that in Canada, the CIM is developing best practices guidelines. I'm looking at your video, Ian, because I know Ian is particularly sensitive about the world, or the phrase best practices, as opposed to leading practice. And I guess for the audience, we have to understand and appreciate that anything dealing with social is dynamic. So as soon as you think you got best practice, you're already behind. So consider that leading practice document when it does come together, and it is in a near final draft form now. When that does come out, it'll be just a snapshot and things will already be moving forward. But we're hearing about this happening all over the world. Numerous countries are working on these things. So the question and ask the context here of a challenge is, with all this happening and so many countries doing different things, mostly suited to their domestic and their domestic influence internationally, is it a duplication of effort? Is it wasting time and effort and one country trying to position themselves into a pecking order above another and trying to get to a finish line and just getting a document out there? Wouldn't it be better to have a single set of global standards? And if so, who develops that? Anybody?
I can chime in. I think it's a challenge. Frankly, there's money to be made in creating these frameworks. So you're going to have competition unless there's regulation, unless the government chimes in to say, this shall be the party that does it. It's going to be hard to try and reduce the duplication to address what you're talking about, Joe, because that's a real issue. And again, it's a new form of capitalism when you look at the race to, put out your own standard and sign up as many people as possible to it. So I right now, off the top of my head, apart from seeing some sort of government input into what they will mandate or what regulators, be it, professional houses mandate, that's the only way you're going to get the reduction.
If I can just add, so I think that in some cases we have all these standards and frameworks that are country driven or specifically industry driven, and they're done by this entire new, well, it's not a new industry, but this whole ESG industry that is just, and I think I agree with Sharon when she said, it's grown faster than COVID. Absolutely right? Everybody seems to be an ESG expert. But I think that if you look at certain specific aspects to it, and if you look at, for example, human rights, and if you look at, for example, what Sherry has presented and the work that the core is doing, these aren't standards created by different countries. There is a floor created by international human rights law. And that is the standard. It is not a standard that can be modified willy-nilly by different experts, right? It is much more set in stone. And I think that this is one of the main differences between the CSR discourse and the business and human rights discourse, because the business and human rights discourse is actually layered within specific law. It's not a nice to have, right? It's not philanthropic. It's actually a requirement, and it's a must based on law. So I think that really makes a huge difference in certain aspects of the ESG discussion.
Thank you, Daniela, for making my point. It's exactly what I was going to say. I was going to say, fortunately, the core is not guided by standards or best practices. The core is guided by international human rights covenants, treaties, declarations, that are global. That's our guidance. We may look to standards, in our assessment of things, but we're guided by these very global international standards. So that's, I think that's really key.
We're all talking about different things, right? So, and that's where nuance of the point is so important. Who is the audience for this? And sorry, exactly. Ian, I think I cut you off, so please go ahead.
No, it's okay. It is important to know who the audience is, but it's also important to know where you are on the ground, because I grant you that at this higher level, if we take a human rights lens, we can be very, very effective at pinpointing, problems and irregularities. But there is also political context and cultural context, which varies from country to country, from region to region. And it's the way things are, the way things happen, the way they're implemented on the ground, which is really where the rubber hits the road. And that's where a lot of this standards generation has focused. It's what you do. It's not how. It's how you do it. We're pretty good about the why we do it, and not too bad about what to do it. There's an awful lot about how to do it at the detailed level, and there's an awful lot of people climbing into this from I think from a very poor platform. One of the things that was, we had a social practice forum meeting earlier this morning, and someone commented on the number of CSR specialists who now call themselves ESG specialists. If you whip through LinkedIn, you'll see that over the last 6 months, a remarkable number of people have changed their designation. And I worry about that, because I'm not sure that they're really qualified to do this.
Actually, on that point, Ian, you mentioned in your presentation about legal firms, accounting firms, seeking potentially stepping up to be the QP for National Instrument 43-1 Technical Reports Item 21. And you showed that slide where from the PwC website, the reporting follows commonly accepted standards known and trusted by stakeholders. Yet, for some of us that have been highly involved in 43-101, and I was on the CIM National Council to sign in and adopt 43-101 20 years ago, we have recognized that in its various, it's in its third edition right now, 43-101, we have yet to see anybody, in my view, adequately report on item 21. which is your environmental and social impacts of your project. So if that is really the case, PwC is inaccurate in their website. And if that's the case, that you have a large accounting firm, business firm, consulting firm like that, thinking that that's okay, how do we get to okay that's acceptable, not only to the investment community, but into the community at large?
Well, big question. That you know, that quotation, it comes from a fairly high-level statement by PricewaterhouseCoopers. They weren't talking about the mining industry specifically when they made that statement, and presumably they were feeling fairly confident that when they're talking to you know, people in wholesaling, or retailing, or whatever it is, manufacturing in general, that they could defend that statement. But it certainly becomes very much more difficult to do that when we come to things like National Instrument 43-101. We do have the Global Reporting Initiative, but that's a backwards looking document. You're talking about what happened, not what's going to happen in the future. There is really a big problem when it comes to who is making statements that are forward looking when it comes to some of these areas of environmental and social, because there is a lack of I can't say there's a, yeah, in my opinion, there's a lack of accountability, because there isn't the opportunity to have an authoritative statement by someone who is established as being competent to make that. And as a result, companies make all sorts of strange statements about their environmental and social performance. And they do that in their their GRI sustainability reports, and they certainly do it in their forward-looking statements.
Thanks. I'm going to go back to Sherry on a scenario or an issue, and it's we've got this question through the chat that has just been raised, and I think it's an intriguing question. And I'll ask Sherry first, but I posit this to the rest of the panel as well. And in this question here, they're using the Brumadinho as an example. But if we look at not only the Valley incident, which I think is catastrophic, particularly in the terms of life, but closer to home, Mount Poly, by Days of Placidome, we had Markhopper. We can think of many tailing type spills like that have affected human life, environment, and lifestyle afterwards. When we look at that sort of dramatic and catastrophic events, as well as domestic mechanisms to provide victims and their families with redress through tort law, prosecution, criminal law, etc. What does it do to help in any respect to declare these as human rights violations?
All right, I'm going to twist it a bit, or just sort of speak to when would the Corps take on, like, do a review or not do a review? And so, I mean, you point out at the question, ask the question. Well, there's domestic, venues and fora for bringing an issue forward. So where's Corps' role? Well, I mean, and I want to highlight here, Corps is a non-judicial dispute resolution mechanism that has the ability to recommend remedies, and it's voluntary. So if it's criminal, highly catastrophic, I mean, there's going to be, venues within the country that may be more appropriate. And if it's being covered, we probably wouldn't cover it at that time, or that whole, the large part of it. Now we might, at that time or a little bit later, deal with a specific issue, an individual, a community, or an organization, but we're not replacing anything. We are one, venue, and we are a non-judicial venue. So we have our limitations in what we're able to do and how we're able to address things. So people are going to come to us when it's appropriate. And no one's precluded, just because there's a venue domestically, from coming to us. It may be in their estimation, it's a Canadian company, they think that they would get a better hearing from us than they might get from somebody within the country. So, and we're going to, be focused on the company, not the country. And that's the difference between what might be happening domestically.
I'm looking to Sharon and Daniela as the other lawyers to chime in on this as well.
No, I think, yeah, no, for me, Sherry answered it exactly perfectly. I think, I think that one of the things that we see a lot, especially within the mining industry and in certain jurisdictions, is intra-ethnic conflict in which certain Indigenous peoples are not recognized by the government themselves, and therefore perhaps they do not have a grievance mechanism within their own country, and therefore they may look to another grievance mechanism and another fora. And I think that that's where CORE would fit in, just to give sort of a general example. But I think that I don't know if Sharon has anything else to add.
Oh, I don't. You both have covered it.
Okay. Then moving on to the mix again of CSR and ESG from that corporate perspective, and to put it bluntly, lip service versus reality. And just people playing games, whether they are advisors on ESG and CSR, or they're practitioners and have to practice it at the front. How do we bring it all together in practice and seek that solution that is actually needed for investment community and people that are impacted by these projects? What's the motivation for companies to actually execute as opposed to seek the share price? And I think Daniela's slides on Vale and Rio Tinto are quite illustrative in that there is basically, when you look at that time frame, there is a blip when these events happened. So
yeah, and I think for me, Ian really got it like right, his finger right where it hurts. I think the question for me is, where is all this ESG discussion actually impact? Where does it, we talk about, if we look at credit rating, if we look at ESG rating companies, they actually do not do any work on the ground. It is all through surveys in which the companies actually provide self-information. Where do we actually see that ESG parameters and metrics that are, I don't want to say that all of them are, but some of them are, check in the box, where does it actually change behavior? Right? Mm-hmm. It's a behavioral issue. It is, how are companies performing better because now they're more concerned with ESG? Now, we had a question there with regards to how perhaps it didn't affect share price, but then it affected the cost of capital. There were sanctions and fines. Well, all of that ought to affect share price, because ultimately, if we look at share price and the worth of a corporation, it is how many dollars it takes to take an ore out. And if it's more expensive to do business, then your operating costs are more expensive, your capital costs are more expensive, and therefore you ought to be not as competitive as your peers. But as we noted, investors are extremely resilient to catastrophic events occurring within mining companies. How then does this ESG factor actually reflect on the ground, right? I don't know, mm-hmm. Ian, as I said, I think Ian really put his finger on it with regards to impact, change in behavior.
Mm-hmm. Yeah, that's what we would like to see as social practitioners. We'd also like to see, genuinely integrated approaches to these things. Water is a social issue. But it's often managed in isolation as an environmental, actually as a purely mechanical resource factor. How many liters, how many cubic meters per day, this way and that way. Yeah, I mean, there's plenty of. We've come a long way in 20 years in the industry, but there's an awful long way still to go. And corporate cultures are an essential part of it. And there are great cultures out there, really positive ones, but there's still an awful lot of lousy ones. Yeah, and as my position is ESG, I think, has huge promise. There's a great opportunity there, but is it going to deliver? It's too early to tell.
So probably going to be our last address or issue to discuss with the panel before we have to pass on to Susan. Carrying on with this point, but using another example, and they may not like this, but too bad. I'm going to use SNC as an example. TI Canada was involved before it even hit the media. And in that involvement, and eventually SNC changed out a lot of senior people and brought in people to help them apparently change the culture. But they were debarred by the World Bank. And with that external support that came in to help them change the culture, and I've since heard that the culture hasn't really changed in a decade, but they seem to be putting on a pretty face. And we also heard from the federal government, you got to save SNC because so many thousands of jobs would be lost, which was a lie. That doesn't happen in engineering projects. With that in mind, you got a Canadian company that was caught in the midst of an outright corruption activity. And the RCMP investigative services, their budgets were cut, and that investigation group was reduced and diminished at basically the highest levels in our country. Is that now just an ESG lip service and painting and brushing over the real activity that's happening behind the scenes in companies? And how do we address and get to the core of these issues and transparency on these issues, even though when I say the core, I'm not talking about Sherry's role as the core, but to get to the guts of this and to ensure that there's real change within the companies and in government addressing these issues, so that ESG is not just another advertising promotional lip service paintbrush that you're going to get some false information and ratings on. How do we make it real? I could see the gears.
I spoke a lot, and I feel bad because I was the first one out there, and I got a lot to say about these issues. So
go
I feel
ahead,
kind of
please.
mad I'm out there. So I'll let someone else go first.
I think ESG is becoming real in the sense that the regulators are taking notice, and they will they have the ability to concretize things, which will then mean that there is going to be yet another set of boxes that have to be filled in by the companies. So they'll be obliged to take it seriously to at least that level. So maybe that is part of the transition. But I'd like to hear from other people on this one.
I'll do a 20-second one. I'm so conscious of my time going over it. So I think that it's just going to be slow, painful, and incremental. We are seeing an increase in fines. And again, when you're looking at $250 million fine for destroying traditional territory, it's not that huge when you're looking at the profits that are being made. But as projects get harder to permit, because you do have to put these barriers in place such that ESG performance is taken seriously. The ability to access resources apart from those areas that don't have such viable regulatory frameworks, my fear is, yes, we can have those laws in Canada, and we should. You can have those laws in Australia. You can have them to some degree in the US. But what that means is a flight of capital and flight of it might not be a bad thing, a flight of capital to other countries that don't have such rigorous standards. So you need to address that somehow. One aspect of this conversation that's not yet out there is the consumer. And it's the ultimate consumer that also has to drive behavior. So if we are putting, more price on carbon, so to speak, and putting nutritional labels, if I take the example of environment, on how aluminum is produced or how your iPad is produced, then why is it that we can't put a price on the human rights aspect of it, and why can't consumers change their behavior such that you do force the market to change its behavior? So I think it's not an easy answer, and I don't think we're going to get to a solution, but it's going to be incremental. In my view, and I hope that makes sense.
I think there's one area where things have already started to happen, and that is at the level of the international tribunals for settlement. We've seen a succession of decisions made by tribunals, basically telling companies, okay, you screwed up. So, okay, yeah, you got kicked out of the country, you lost your project, or the project collapsed, you're suing the government for compensation. You want 4 billion, we're going to give you 16 million because you screwed up, because you failed either mostly on the social matters. Sometimes it's a combination of social and environmental factors. I think companies are taking notice of that. Certainly explorers are.
Yeah, and as a non-judicial mechanism, CORE would hope to influence company behavior, because we're not going to look at whether they check the boxes. We're going to look at what happened, and we're going to, address that. And it's going to, we have a requirement to publish. And so, if we can't work this through and manage to get the harm addressed, it will be out in the public. It will be out in, for people to see. That is leverage. That does have influence. That we assume that will influence behavior of the company, we hope, and other companies, but also, as has been pointed out, consumers, right? Which will then provide another level of leverage.
Oh, Sherry, thank you for a perfect finish. That was a statement that I really couldn't have asked for any better. And I think that's something that is a good way and a note to finish on. So I'm going to ask Joe Weiler and Susan to step in. But before we do that, I wish to give my heartfelt thanks and gratitude to this phenomenal panel and these people that have taken their time to present to our audience. Thank you very much. That's a virtual clap. Imagine everybody else clapping. So time for to hand it off to Joe Weiler and Susan.
It's really to Susan. She's going to wrap up.
Yeah, I mean, I can't say I couldn't do justice to the discussion today, but I just wanted to say that we learned a lot, but the discussion also raised a lot of questions. So I think it's an unfinished discussion in many ways. And my takeaways are this whole idea of the silos between the ESG and anti-corruption. And I think it behooves an organization like TI Canada and TI more generally to help people make those connections, that these things are connected, and they're connected to your governance generally and to your anti-corruption behavior. So that's something that we need to focus in more. And there's work in TI on human rights and other issues that are connected to ESG, but perhaps being more articulate on how these things are connected would be helpful. The other thing that came up a lot during the discussion was this issue of the plethora of standards. And I just wanted to add to that, that you're not the only ones complaining about this, and there are a lot of reporters who complain about this. And I represent TI on the IIRC Council. That's the International Integrated Reporting Council. And there is an intended merger between this council and SASB, which was mentioned. And I know that the IFRS Foundation has said that it would be creating a sustainability standards board. So I think we're seeing in the market a desire for convergence among standards. And, it's possible that eventually we will get to a point where we have more regulations around this kind of disclosure and therefore behavior. So I think it's a process. We're moving there slowly, and probably too slowly, but I think we're moving there. And I think ESG is there to stay, whether it you know, whether it changes names as we go along, I don't know, but I think it's there to stay. Anyhow, I don't want to keep anybody longer. I just wanted to thank our partners, Center for Business Law and ICLEAR, for putting this, this panel together today and the series of discussions we've been having every month. I thank Joe for moderating and all our speakers, Sherry, Daniela, Sharon, and Ian. And don't forget to become a member of Transparency International Canada. We need all the support we can get and all the vibrant and helpful members we can get. And you can reach us on transparencycanada.ca. So thank you, everybody.